Thank you. Please be seated. All right, thank you. All right, good morning. All right, can we have appearances of council, please? How do you pronounce your last name again, council? Steele Nelson? Stig Nelson, I apologize. The acoustics in this are, obviously this is not designed to be a trial court, so we're used to the lawyers at the podium. So Stig Nelson. Okay, council.
And Assistant Attorney General.
All right, thank you. And Mr. Stig Nelson at council table with you is? All right, Mr. VanDussen, welcome to the Court of Claims. All right, we have just a moment. I told my staff I'm having some issues with my back, so if you see me grimace, it is not in response to anything or anyone or any statement or any principle of law or anything else. It's simply that my back hurts. So I apologize ahead of time if that happens, but I don't mean to be discourteous to anyone. And I hope I will, as they say in baseball, keep my game face or something. But anyway, so that's where we're at. Okay, so today is the date. And this is the time set for oral argument in the matter of Eric VanDussen versus Dana Nessel, case number 22-000161MZ, to address the defendant's motion to stay discovery, the defendant's motion for summary disposition, and the plaintiff's ex parte motion to show cause and for a status conference. The order that we're going to proceed in is the defendant is going to argue first. We're going to address all three while you're up at the podium. I just think logistically it's easier than having three separate, and distinct oral arguments. So, but the first thing I want to hear about is the motion on summary disposition, and then the motion to stay discovery, and then the show cause. That's generally how I would expect we will proceed. I have had the opportunity to meet with both of the law clerks assigned to the Court of Claims, who are exceptionally gifted and bright lawyers, highly experienced, who have helped me to understand the case and the proceedings. I have read all of your pleadings. I've read most of the cases that you cite, although Mr. Stig Nelson, I haven't read all the federal cases you cited. I have read some of them. So I will not say I have read every single case, because I haven't, but I've read most of what I think is a controlling authority that you all have relied on. And then we've done some independent research on our own. So with that, and I say that, not that I would think that either of you are going to stand up here and read your brief, but if that is what you start to do, that's not going to last real long. So I have a number of questions for both. So I don't have anything further I need to address before we begin the actual arguments and the discussions here today. For the plaintiff, Mr. Stig Nelson, anything you want to address before we get started? Thank you, Mr. DeBear. All right, thank you. All right, the people have made a motion on behalf of Dana Nessel for summary disposition and the other motions for relief. Please proceed, counsel. I would, simply because we're live streaming, and my understanding is from our case call in the Court of Appeals is that it'll be easier to pick up what you say from there. So, and frankly, it'll be easier for me to hear it. So.
Well, again, may it please the court, Assistant Attorney General Adam DeBear, appearing on behalf of Attorney General Dana Nessel. And I basically have just some high-level topic points to discuss. And if Your Honor has any questions, feel free to interrupt as I go along.
Thank you.
With respect to the motion for summary disposition, the basic premise is this. All of the information that were submitted or displayed during the preliminary examinations in Antrim and Jackson County has been, as plaintiff states in their brief, presented to the public. They've been introduced, as it were, into the public domain. That said, because it's been introduced into the public domain and because plaintiff in particular has a much greater knowledge of the at issue material here than an ordinary FOIA plaintiff would in another type of case, the need for discovery and in particular, the need for the strict adherence to the evening rules, 3 steps and 6 rules.
All right, please continue.
And yes, as I was saying, Your Honor, Mr. VanDussen's knowledge in particular in this FOIA action is much greater than the ordinary FOIA plaintiff who is bringing a FOIA lawsuit against information or seeking information from the government that has otherwise not been disclosed or not introduced, and there's a real informational imbalance or disadvantage at play. So that's the difference here. Here, there is no information.
That's as relates to if we get to discovery.
If we get to discovery,
Okay,
sure.
I'll ask you questions about that. What I want to know is why do the people think that MCL 15243 sub 1, sub B, sub 1 through sub 3 apply to this case?
Well, I think the most important of those subparts is B2, the fair trial rights.
Can you cite me any case in the United States of America where a trial court has concluded that under either a state or federal FOIA application, documents that were introduced in open court, admitted onto the record of a public hearing, are deemed to be investigative materials?
Well, I think every one of the cases that we cite would say those records are investigative materials. The question is whether those investigatory records fall under one of the B sub I through sub 3.
Is there any case in America where a trial court has held, once introduced in open court, the documents are still exempt from disclosure?
So as it relates to the public domain doctrine, in that portion of my brief, I don't have the case citation handy for me, but it was most likely in my reply brief, Your Honor, because I believe plaintiff introduced the public domain doctrine in their response brief. And in that case, or in that brief, I note that there are several federal courts, federal circuit courts of appeals, that have held if the purpose of the exemption can still be fulfilled, the public domain doctrine is not a bar to the exemption. And I do cite, I think, an 11th Circuit opinion in there. And that's the one that's coming off the top of my head, but I believe there's 2 separate opinions I cite. And that's the proposition. If the purpose of the exemption can be fulfilled, then there is no bar to the exemption. As it relates to these particular exemptions that the Department of Attorney General is invoking here, Your Honor, I cannot point you to any Michigan case law on point for those propositions because, to be frank, I don't think that the courts have addressed it. The reason for exempting these particular records is set forth in Danielle Hageman Clark's declaration. And it is that belief that is core and central to her role as a prosecutor, that if we, the Department of Attorney General, are releasing these preliminary examination exhibits to the media, particularly in the case of the Antrim County defendants, who have yet, they've been bound over for trial now, but they haven't yet had their trial. If we do that, we are flooding the jury pool with more news articles and more information related to—
How do you square that proposition with ESPN News versus Michigan State?
Well, I believe in ESPN,
which required the release, not of defendants' names who were under investigation in open or hearings from after an open public hearing. They required the release in that case of the names of athletes in an unredacted form who were merely accused. And this court said that when balancing the principles of FOIA, those names had to be released, that the names and addresses of witnesses did not. How does your proposition that we have to protect the right to the right to a fair jury trial, which of course this court completely endorses and accepts, and having had the privilege of being a trial judge for 12 years in the circuit and 5 years in the military, highly value, of course, but how is that exception applicable to this case?
So, and the case will correct me, the opinion will correct me if I'm mistaken, but I believe in ESPN versus Michigan State University, the exemption at issue there primarily was MCL 15-243-1A, which is the personal privacy exemption. And in that particular exemption, there is a balancing test that is put forward there. I don't have the statute in front of me, but I believe it has to be a clearly unwarranted invasion of privacy. And the balancing test, such that, disclosure that is substantially outweighs the public interest in disclosure. And in that particular lawsuit, the public interest in disclosure, as may be the case here, was particularly high, given it was a public state university and a fairly big investigation. Here, however, where there is an active law enforcement proceeding, the criminal actions against both. So just setting the table a little bit, I believe the Jackson County defendants, Your Honor, have been sentenced and their appeals are pending. The Antrim County defendants have been bound over for trial, but that trial, I think, is taking place sometime in the summer. But
all right, so what the case law seems to suggest that the trial court's responsibility is to look at what the status of events was on the day the FOIA requester submitted the claim. Do you agree or disagree with that proposition?
I do agree with that proposition, but I'm not 100% convinced, Your Honor, that that is a universal application through FOIA, because in the, I believe it was Krug versus Ingham County Sheriff's Department case, at the time the FOIA request was made, it dealt with investigatory records. There was an open investigation. The request was denied because it was an open investigation. A lawsuit was commenced. And during the course of the lawsuit, they found out, hey, that investigation had opened. And so there was a duty the court held there to produce those additional records because the exemption no longer applied. So, all right. Sorry, I interrupted, Your Honor.
So the matters of People v. Beeler, People v. Morrison, and People v. Musuko from Jackson County, trials have been completed.
Correct.
Defendants have been sentenced.
Correct.
When were they sentenced?
Off the top of my head, I'm not sure, but it was after the time, I believe after the time we filed our dispositive motion. So I'm going to say it was in early 2023. When Mr. Stig-Nielsen comes up to give his argument, I believe that he or his client will have that information off the top of their head.
With regards to the Antrim defendants, Mr. Fix, Mr. Higgins, Mr. Molitor, Mr. Null, they've been bound over. Is that correct?
That's correct.
Were they bound over at the time that the FOIA request was made?
No, they were not.
But they have been since.
They have been.
In your production, in the plaintiff's responsive pleadings at page 22, paragraph 26 of the plaintiff's affidavit, he speaks to 458 pages of a PDF and 30 MP3 audio files that were provided. Tell me about that, about those.
So if I'm remembering that portion of plaintiff's brief correctly, I believe that was information related to the Jackson County defendants, because at issue in this FOIA lawsuit was the request for preliminary examination records. And all that was produced, to my understanding, were memes that didn't really identify who the poster was or who the particular, defendants were. Those records were trial exhibits, and being candid with the court, their production is contrary to the justification set forth in our declaration. However, that production, Your Honor, I'm submitting to the court was the result of a human error. It was just a mistake that those records related to the Jackson County trial, the Jackson County trial exhibits being produced in that substantive format with all the MP3s and the redacted pages. That was something that shouldn't have happened, and it did by mistake. The department's position is still that so long as there is a claim of appeal or an appellate rights left for these defendants, that the prosecuting attorneys in our department and the department as a whole have a duty to protect their fair trial rights to privacy, and also the
Why can't they interplead in opposition? If they what that's a right. The right to trial, to the fair trial, is the right of the individual who is accused by the governmental agency. Fair?
Fair.
So why does the Attorney General have standing to assert that position? As opposed to, if they opposed it, they could interplead or seek to interplead and oppose.
They very well could do that, and they have the right to do that. What Your Honor asked, that particular question, let me just say standing, we have standing because we were the public body with which, or to whom the FOIA request was made, and those are the exemptions we asserted. But Your Honor makes a really good point. It's not our rights. Those aren't our fair trial rights, but the prosecuting attorneys in the department are tasked by the rules of ethics, by the Constitution, with protecting the rights to a fair trial. And win or lose, Your Honor, what would be the most beneficial for the department going forward is a published opinion in this regards, because oftentimes public.
I'm just a trial judge. So
right, but
somebody else will figure that out.
Right, but if regardless of what happens here, if this goes to the Court of Appeals, a published opinion ultimately is going to be very helpful for two reasons. Public body is always in these cases between a rock and a hard place. Right. Because on the one hand, if we produce, well, we have accusations from the criminal defendants that we're impeding on their fair trial rights. We have the potential of liability under 42 USC 1983 for perhaps abuse of process, because when a jury comes into a trial court and they already have an opinion of the matter, I have
to decide whether or not I grant summary disposition. I don't have to decide whether or not a published case would be helpful to the advancement of law in the state of Michigan. So let's stay on task. I understand that the argument may very well be made from the very podium you're standing at, but it'll be to three of my colleagues, not to me.
Then let me go back quickly to you mentioned ESPN versus Michigan State University, and I don't think I finished the distinction. So, and I'll call it Section 13 of the FOIA is where the exemptions are. So Section 13(1)A is privacy, and 13(1)B are the investigatory records. When you compare 13(1)A with 13(1)B sub 3, I believe, is privacy. There is no balancing test in that privacy prong for that exemption. And it's also not a clearly unwarranted invasion of privacy. It's just an unwarranted invasion of privacy. The difference between unwarranted and clearly unwarranted, I can't point you to any published cases that provide that authority, but they're clearly different. And I would submit that it's a lesser standard under 13(1)B sub 3 because of the plain language of the statute. And those are the three exemptions that are at play here, Your Honor. Fair trial rights, the right to privacy, particularly the rights of the accused who have yet to be, especially in the case of the Antrim County defendants, found guilty by a jury of their peers. They have the right to, they're presumed innocent until proven guilty. And so disclosure at this point in time would violate their privacy rights.
Your written submission says we don't have to disclose as a matter of law until the appellate rights are exhausted.
Correct, Your Honor.
Okay, so you have a preliminary, after a felony conviction in Michigan, you have an automatic right of appeal.
Correct.
And that can take 12 to 24 months.
Correct.
And then you have a right, if you're an unsuccessful litigant at the Intermediate Court of Appeals, the right to petition the Michigan Supreme Court, correct?
Correct.
Asking leave for appeal. If they grant MOA or if they grant full argument, we're talking about a year to 2 years more. Fair?
Fair.
And once that is completed, you have a right under Michigan Court Rule 6.500 et sec et period seq period to then ask for a new trial for whatever reasons you seek as an individual who's now been accused or now been convicted and whose direct rights of appeal have been exhausted. You can do a 6,500. Fair?
Fair.
Okay. And after the state Supreme Court denies your application, you can actually file, and for a long time, Michigan was a great source of cases for the US Supreme Court. You can apply for a petition for certiorari. Fair?
Fair.
Okay, so that the direct appeal process could take 5 years. Fair?
Fair.
And then we have the habeas, and that's 6,500, and that can be another 1 to 2 to, we have habeas petitions and motions for reconsideration of habeas decisions in our court that are 20 years old. When does and then after the 6,500 is done, you can petition the United States District Court under the US Constitution and Title 18 and Title 28. So you don't have to disclose anything till all those are done?
What I think after you get past the claim of appeal that you have by right, I think the calculation changes a bit.
Why? There's nothing in the statute that says it does. There's nothing in the Constitution that says it does. Quite to the contrary. The Constitution says you can appeal.
Correct. So the court rules, and I believe the Constitution provide for an appeal of right upon a criminal conviction.
Mhm.
But after you appeal to the Michigan Court of Appeals, all the other relief that you could potentially receive from the courts is discretionary. There is no appeal of right to the Supreme Court. You do have the ability to file a 6,500 motion, I believe, as right, but those are,
You do.
in my experience, rarely successful. And the same with habeas petitions in federal court after you've, exhausted the necessary administrative steps and,
If that's what the legislature wanted, then in 15.2.43, why doesn't it say B 3 sub A or something? And this applies until the direct appeal is exhausted. Because it doesn't say anything remotely close to that.
You're correct, it doesn't, but the important thing to matter is that, or the important thing to keep in mind is that the FOIA cannot, as a matter of well-established case law, cannot supersede the fair trial rights granted by the Michigan and the federal Constitution. This is a particular area in this, and I understand
but
again, that this is a trial court. But
I think that the problem I'm having tracking with your argument is the FOIA exemption says investigating records compiled for law enforcement purposes, but only to the extent that disclosure as a public record would do any of the following. Once something becomes Exhibit A and is admitted after motion of the people as an exhibit in an open courtroom, not subject to a protective order, not subject to a sealing order, not subject to a closure of the court order, how is it still an investigating record? How has it not now transformed into simply an exhibit at trial?
Well, the plain language of MCL 15-243-1B, not getting into the subparts, records compiled for law enforcement purposes.
Investigating records, counsel. How are you investigating when you've asked the fact finder to either A, find probable cause, or B, the petite jury to find beyond a reasonable doubt that person A did subject something B?
I'll submit two things. So one, those records are always investigatory records because that's how they were compiled. Just because they're investigatory records, on the other hand, doesn't mean that they're exempt from disclosure. I'll acknowledge that. And the second part of the question, so interference with ongoing law enforcement proceedings, Your Honor, the prosecution doesn't stop investigating its case simply after charges are filed, simply after a preliminary examination is held and the defendants are bound over. If the defendant, for example, decides to take the stand, or other witnesses take the stand that bring new information to light, well, the prosecuting attorneys and the law enforcement officers that they're working with have to go and investigate those new claims. As a matter of course, now, do
Counsel,
prosecutors
I was a federal prosecutor with the Department of Justice for 8 years. I was a United States naval officer for 28 years. I was a prosecutor. I was a defense counsel. I am very familiar with the investigative process. I don't mean to be discourteous, but of course, law enforcement, they have a sworn duty to continue to investigate. No one quarrels with that. But the question is, once these documents have been made public records in a public trial, how do these documents continue to possess that status which exempts them from disclosure?
That's where the language in sub I through sub 3 are important, Your Honor. They're always going to satisfy the first prong in 13(1)(b). They're always investigative records. Whether they maintain their status as being exempt from disclosure depends on one, whether they would interfere with ongoing law enforcement proceedings, two, whether they would deprive someone of their right to a fair trial, and three, whether they would constitute an unwarranted invasion of privacy. I don't remember sub 4 through sub 6 off the top of my
I
head.
think 1 through 3 are the really relevant ones.
That's the question that is important with respect to, as a criminal investigation proceeds from the investigatory process to the filing of charges, to the preliminary examination trial, at what point in time does the disclosure of those records stop interfering with ongoing investment, stop depriving?
I wouldn't, how does the subsequent disclosure, because you've already disclosed them.
Correct. We have presented them in open court. There's no contesting that. And I go back to Your Honor's question about whose right is it? The most important exemption here is are those fair trial rights?
Counsel, every trial judge who has ever tried a case which has substantial publicity has, during the voir dire process and during the initial charging process and during the final jury instruction process, inquired specifically using standard jury instructions authorized and approved by the Supreme Court of the state of Michigan that ask, this case has had some publicity. Words to this effect. Are you able to set aside whatever it is that you may have heard of, talked about, or whatever? I mean, it's, as you know, I had the privilege of serving on the Kent Circuit for 12 years. I didn't ask that in every case, but I certainly asked it in more than 10 of the 230 jury trials I presided over. And some jurors, they answer no. Some jurors answer, I can't set it aside. Some jurors ask about it or have heard it. Every single time, in my experience, a juror responds in any way, the courts are very liberal with the follow-up voir dire and challenges for cause. I understand in your brief the argument that such a that may not be enough for something. Maybe I don't understand the argument entirely, but you've addressed it in your brief. But we have highly well-known cases where individual members of our community are facing very serious charges that have been reported on extensively. And the trials go forward. And I'm not aware of there ever being, and in any of the cases I had the responsibility to preside over, even an assignment of error on that issue, it being raised on appeal. So, I mean, we know that there are some cases that have more public attention. Why doesn't that mechanism that has worked since we've been a state in 1837, why doesn't that continue to work now?
Well, there's no way, there's no crystal ball that the department has that it can say for certainty, if you disclose all of this stuff, it is going to taint every available juror in the 13th, I believe it's the Antrim and Grand Traverse right now. There's no way that we have a crystal ball that we can say every single juror is going to come in there with an opinion already preformed. But if there is a juror that does have a preformed opinion, that is a violation of even the most basic due process standards.
But how is the process that we engage in voir dire not adequate to address that?
When you have a case with the amount of publicity surrounding an attempted assassination or kidnapping and assassination of the governor that's been in the news as much as it does affect it. This is a very newsworthy case, and this is a very serious prosecution with serious allegations. Mm-hmm. And both the people of the state of Michigan and the criminal defendants have that right to a fair trial and have that right to a trial and a jury that hasn't come in with a preformed opinion. We produced those exhibits or displayed those exhibits in open trial. Again.
And you gave them to the trial judge.
And we gave them to the trial judge.
You asked the trial judge in argument, not specifically these words, but words to the effect of, you're making, whoever is representing the people at that point in these hearings has said, we've shown there's probable cause. We've shown proof beyond a reasonable doubt. I'm assuming those are something along those lines was argued, right?
Correct.
Okay, so they've already been relied on to a petite jury. They've already been relied on to multiple preliminary exam district court judges, and or I assume were they district court judges who?
Yes.
Okay.
In both cases.
So we've given them to our elected official, who's the judicial officer, to review. We've given them to our fellow citizens who are petite jurors to decide the innocence or guilt of a fellow citizen. And we've said rely on them. But now we're saying it's still protected under the 1 through 3 exemptions.
And more importantly, Your Honor, under the Michigan and federal constitutions, under that right to fair trial, because disclosing those.
Is there any case in the history of the United States of America, in any state, territory, or federal court, which holds the proposition that you're suggesting?
The closest that I can point you to is what I represented earlier with respect to the public domain doctrine.
That was a civil case.
Well, those are FOIA cases, but
you're right. But you've introduced this information. Okay, so I think the short answer is probably no.
No, and the case that I cite again, and I believe it's a U.S. Supreme Court case, talks about when jurors come in with a preformed opinion that violates even the most basic standards.
Of course it does, and that's why we engage in robust voir dire. And whether or not these exhibits are produced, or were produced, or were introduced previously, I can't even imagine a scenario where the trial lawyers and the trial court, in the allegations giving rise to these underlying cases, wouldn't be involved in very substantial voir dire of veneer members. I haven't read the transcripts, haven't had to do that yet in this case, and hoping, well, I'll do what my duty and I'll read what is necessary. But so we have these processes in place. Okay, I understand your position. I do have a couple other questions.
Right. But if you don't mind, Your Honor, just wrapping up with the exemptions and
I want to ask some questions.
Oh, go ahead.
Thank you. Okay. Is the Attorney General a proper defendant? And if they're not, if the Attorney General herself is not a proper defendant, what's the remedy, if anything?
Well, one, the Attorney General is not a proper defendant because she had nothing to do with the underlying FOIA request.
There were a bunch of cases cited by plaintiff's counsel in a footnote where the AG was a named defendant. I think I did not drill down and look at all those cases. I'll be perfectly honest. So you've indicated in some of your pleadings that if they move to amend to name the department, you wouldn't object.
No, we wouldn't. We recognize that amendments are freely given and the substance of this lawsuit is what the court's most concerned with. But
right.
if that's what the plaintiff wants to do and maintain a lawsuit against the Attorney General herself, who didn't have anything to do with this lawsuit, they can bring those allegations, they can make those claims in public, but dismiss the complaint if they're not going to amend it.
If it's an amendment, would the relation back doctrine relate the amended complaint to the initial filing date?
Well, I haven't had the time to think of that. I think generally if new parties if new parties are added, it's different. But I can't think of a reason why it wouldn't relate back in this particular instance. That was an affirmative defense that we raised. It was addressed in briefing relatively early on in the case. And I believe the lawsuit was actually filed pretty closely after the denial.
It was. My recollection was.
So
okay.
I don't think that's a particular issue here. I haven't looked at it thoroughly, but in those other cases that Your Honor references, I know for a matter of record, and I won't get into which case, but I'm the attorney on one of those cases. And in one of those cases, we submitted the same affirmative defenses, and then the plaintiff amended their complaint and named the department.
I see.
Forward.
Okay.
In those other cases, I suspect it just wasn't litigated, but the
right.
Attorney General did not have any underlying role in the review of the FOIA request, the denial of the FOIA request. In fact, the FOIA allows you to submit an appeal to the head of the public
right.
body, but again, that didn't even happen here.
In another life, I had the privilege of serving as a head of a state agency, and I was trying to rack my brain, and we would have FOIA requests. Had the privilege of serving my sisters and brothers who wore the cloth of our nation in the Veterans Agency, and that was a enormous privilege to serve them and their families. And we did get FOIA requests, but I don't remember. And we got sued, of course, because we're a big agency. I don't remember in a FOIA situation where I had been named, and it's not relevant to this case. And obviously, I'm not going to be impacted in my decision, but I was trying to go in the Wayback Machine and remember. I just couldn't. I remember getting appeals, and we'd work through them. But at any rate, and I don't know if we even were sued when I was there. We may have. I just don't remember it. But there were a lot of moving parts back in those days.
I just briefly submit that the answer to that Your Honor's question is presented in the FOIA's plain language MCL 15240. That's who you can sue, and that's when the claim, to sue under the FOIA accrues, and it involves the public body when the public body issues a final determination. AG Nessel did no such things here. I'm happy to answer your Honor's other questions.
Okay. Yep. Let me go through my notes. At the trial court, in one of the pleadings plaintiff has submitted, there is some, and I looked for it and I apologize, I just can't find it to find the right place. There's a discussion, and I don't know whether it's a quote or a summary of what the attorney on behalf of the people said to the court when exhibits were being admitted and talked about FOIA. Do you remember that?
I do, Your Honor.
Okay.
I don't remember it verbatim.
Right. I don't either, but I got the impression. Well, what do you think your counterpart said at the trial court about FOIA, if anything?
Well, I can't, the transcript to a certain extent speaks for itself, but what I'd submit that then Assistant AG Dodamani represented to the court was make the request through FOIA. FOIA is the appropriate mechanism through which to get state records. I don't think she made any references or promises that
Okay, that's where
exemptions
I'm
wouldn't
getting
be
at. Yeah.
applicable or anything. But
All right.
again, the transcript to a certain extent does speak for itself.
Okay. All right. I'd like to ask you a couple of questions about, let's assume for a moment that despite your very capable advocacy and briefing, that the court doesn't agree with you and that you're denied summary disposition. What, in your mind's eye, what happens next? Other than you appeal, they're seeking interlocutory appeal, and that's denied because my colleagues on the Court of Appeals are going to let it play out in the trial court like we always do. I'm sorry, I don't mean to presume to speak for the 22 judges who will not be disqualified from hearing this case. And I'm not, and to the extent, and I apologize, I know this is a very serious case. So if my very immodest attempts at humor shouldn't be taken as anything other than crystal clear recognition. This is very serious for the people. This is very serious for the plaintiff. I recognize that. It's a serious matter and with far-reaching ramifications.
Understood,
I get
Your
that.
Honor. No,
Okay, so
no
I don't want any, sometimes, anyway, so with that description, what happens if the motion's denied? How do you see what happens next? Or should something happen before the court denies the motion? Should I be reviewing things in camera? You know, that's the sort of status conference piece of this, of us being here today.
Right. I would submit that Your Honor has all the information you need to decide this case. I think it is a straightforward legal issue.
Okay.
And that's what I was addressing at the beginning of the hearing. In ordinary FOIA cases, you have presumably a secret document that the plaintiff knows nothing about, and the department is supposed to describe with particularity, submit a bill of particulars about how in particular this document would interfere, you know, et cetera, et cetera. That's not the case here. Everything has been admitted to a certain extent in the public domain through those hearings. Mr. VanDussen in particular has attended, I believe, all of the Antrim County hearings, and at least with certain of the Jackson County hearings, he either attended or viewed via YouTube, has the deposition transcripts available for those, has the list of, you know, through the transcripts, has the list of all of the exhibits that were admitted and descriptions of them. And in fact, we did attach the actual exhibit lists that were provided to defense counsel and to the court during those preliminary examinations to our reply brief in this case.
Right, right.
So
you waited, or no, you blocked out some names or something.
Correct.
The vast majority was provided.
Correct. And we redacted the names consistent with our, you know, proper
Position you've been taking
Correct.
so far. Right.
And to that extent, there is no additional discovery that needs to happen or other briefing that needs to happen for this court to issue a determination. I mentioned earlier that this is an important issue because these aren't necessarily, I mean, they are our fair trial rights, but they're also the criminal defendant's fair trial rights. Sure. And, you know, same thing with privacy, you know, the department, like, it's not our right to privacy, it's their right to privacy. And because these exemptions are discretionary in FOIA, we can take them, we don't have to take them. A written opinion with clarity would be very much helpful one way or the other, and no additional discovery needs to happen for it to take. I'm happy to address the specific potential deponents that plaintiff wants to depose and answer your questions about the motion for an order to show cause, or more particular questions about our motion to stay discovery as well.
I think I've probably, let me just take one last look through my notes.
When Your Honor is looking, the mandamus issue is somewhat different. The mandamus issue is somewhat different than what we've discussed earlier. I think it's well briefed, but that's the.
Well, I don't think you have to talk a lot about the mandamus. I suspect the plaintiff's counsel is going to have to talk about mandamus if they seek that relief. which they have a motion for. So, or not, I'm sorry, a prayer for relief and a complaint. So, okay, all right. Thank you. You have, well, I'll let you know whether I'm going to let you have rebuttal or not.
Understood. Thank you, Your Honor.
Is everybody okay to keep going for now? Okay, ma'am. And if you do need to have a short recess, you could let me know, that'd be great. And again, I'm so unaccustomed to not being able to see the court reporter, but thank you for helping and being with us.
Morning again, Your Honor.
Morning.
May it please the court, Frederick Stignelson on behalf of the plaintiff, Eric VanDussen.
Let me just. I don't mark the pages. I'm looking at my notes. I'll forget who said what. Okay, Mr. Signoson, thank you. Thank you for your briefs. Thank you for yours and your client's submissions. And he was pro se at one point, so I've of course read his submissions as well as yours. Appreciate it. I don't believe we've met before. It's nice to have you in court. So,
Well, I'm
Thank
sorry
you.
about your back.
yeah.
I know how that is. It's not healthy being an attorney. Or
I
probably a
know,
judge.
I know. We said so much. It's gosh, it's I was pushing an ATV on Monday that decided it didn't want to run anymore. And I think that pushing an ATV up a ramp to the bed of your pickup truck is it's more force than that part of my back normally feels. So it was I
You
think
never realize it until.
right. Of course, it happened, you know, about 2 hours later in the car. I'm like, oh my gosh, I really don't feel good. So anyway, thank you. It's very kind of you to say. So I'm sorry for my weakened condition, but I'll do my best to do my duty. So please go ahead.
So just zeroing in initially on the C10 portion of the defendant's motion for some. Looking, generally at the rules of construing the facts before the court, and of course, remembering that the court should be liberal in finding a genuine issue of material fact, and remembering that that really it's looking and finding beyond a reasonable doubt that there's not an open issue.
Well, that's not the standard. Beyond a reasonable doubt is applicable in criminal standards. It's whether or not, taking the facts in its light most favorable to non-moving party, that there's no material issue.
And Your Honor, respectfully, in preparing for today's hearing, I found several citations, one of them being Shalal, that's SHALLALV Catholic Services of Wayne County, 455 Michigan, 604 at 609. That's a 1997 case, where the court said a genuine issue of material fact exists when the record, giving the benefit of reasonable doubt, leaves open an issue upon which reasonable minds might differ. And I understand the court's invocation of the standard, but really, I guess, big picture, there are so many questions of fact that are not answered at this point in time. And why they're not answered really goes to the declaration that was submitted by the defendant in response to, in an attempt to provide a sufficient justification of particularized facts. I am unaware of any case law, of any rules when looking at evening news, that because of a plaintiff's knowledge and the identity of the requester,
It's not relevant.
it's irrelevant. So the 6 rules in the first step of evening news apply.
Right, but why? Assuming we get that far, I don't disagree. Okay, I understand.
The penultimate flaw really with the declaration is that it invokes all 3 exemptions for all of the records wholesale. There's no effort on the part of, and really what we've heard today from the defense attorney is the most particular attempt to do a particularized justification, but obviously the attorney's statements here in court are just argument. That's not the affidavit. That's not the declaration that's required by the law. And so in looking at Ms. Hagen.
Well, the declaration of the individual affiant was, here are the reasons why we have an ongoing investigation. It's going to affect the rights of the criminal accused, and they have privacy rights and words to this effect. I mean, they don't specifically provide, a bait stamp serious of documents. So, anyway.
And that's the problem, Your Honor. That's really why, in essence, motion for summary disposition is not appropriate at this point in time. When we look at it's a three-part request that the plaintiff submitted. You know, the first one is for the exhibits at the Antrim or at the Jackson County preliminary examination. The second portion is for the exhibits that were introduced at the Antrim County preliminary examination. And the third portion is the exhibit lists that were in any way related to the exhibits.
Why do you think you get an exhibit list that was produced by counsel? I mean, if they asked you for your, and you're not a public body, but let's pretend you're the public body. You get ready for trial, you put together an exhibit list. How's that not attorney work product?
Well, the question is the entire exhibit list attorney work product, or are there redactions that could be made? Because again,
But you're not suggesting that the attorney didn't create it. That which you seek, is my understanding of the exhibit list, is there's no averment that it was anything other than created by a lawyer on behalf of a party in preparation of litigation. Fair?
Fair.
Okay. If that's the case, then how's that not attorney work product?
Well, because the exhibit list that's now been turned over as exhibit B to the defendant's reply brief was given to all of the parties in the court, was provided to the court in the binder with the exhibit, and was really just a guide to guide the court as it was examining.
Right.
At that point in time, I don't think it's any longer protected by the work product doctrine.
But you have that now.
And to, I guess, to cut to the chase on that, if the court is going to grant summary disposition on anything, as to part 3 of the plaintiff's request, the plaintiff has prevailed because this lawsuit allowed him to get that exhibit. In the initial response that was written by the FOIA coordinator, everything was withheld except for the 47 means.
Statute allows agencies to supplement their production, and that's what they did.
And they didn't do it until the plaintiff filed this lawsuit, and they wouldn't have done it. And they didn't even do it, Your Honor, in the declaration. The declaration kind of broadly, vaguely references, it references more specifically the internal master list, which I understand there are some factual inquiries with regard to the attorney work product doctrine. But I would again submit that you can provide a sheet where you've redacted everything except for master exhibit list and maybe some page numbers. And that's the kind of careful, careful discernment of exempt versus non-exempt material that's required by the FOIA. And that's what we don't have here. Because again, we have this wholesale invocation and just saying the entire exhibits are being redacted. Something else, in looking at, for example, the preliminary examination transcript, there are references to both redacted exhibits and unredacted exhibits. And again, it shows the capability of making that call and saying, if this exhibit has an address of someone that we don't want to disclose, well, then let's redact that. If it has a face of someone, but is the background protected by FOIA? Is the background constituted? That we don't have, we're guessing because we don't know, Your Honor.
Do you think if the document was admitted at a hearing in a redacted form, do you believe your client is entitled to that under FOIA?
Yes.
If the document exists in an unredacted form and may have other information, or maybe it doesn't, it's something, you've got a clean copy and a redacted copy. All of us who've been trial lawyers know how this works. You've got your exhibit book, and then you've got your exhibit. Oh gosh, we forgot to line out, John Smith, because John Smith's the cooperating informant. We don't want John Smith's identity known, or we don't want John Smith's address known, and you redact that. And you're not suggesting that you're entitled to the unredacted copy of the admitted exhibit, are you?
If it doesn't fall within one of the claimed exemptions, then the department can't, with their burden, the burden being on them, can't justify the claimed exemptions. I would say, yes, a requester would be entitled to it, because again, it's a pro-disclosure statute. The court has already looked at the embedded limiting instruction in the section of the exemptions that we're dealing with and said, look, yes, I mean, there's a limitation within within that exemption, saying, they have to justify it. And so that's the concern, Your Honor. And just as a couple of examples, I think really looking at something that we didn't have the benefit of having, of course, when the plaintiff responded to the motion for summary disposition, is the exhibit list the exhibit lists which were provided as Exhibit B into the defendant's reply brief.
Is that from the Jackson or Antrim case?
There had both, Your Honor. And there's two exhibit lists. There's one from the fixed monitor, no Higgins exhibit list, and that is what it's labeled, Your Honor. Again, and then Morrison musical Beller exhibit list. One of the exhibits that is referenced in the fixed monitor, no Higgins exhibit list is a picture of Adam Fox, and Adam Fox's name isn't redacted, looking at the governor's house. And this is a picture that has been widely distributed in the media. Again, he's not a defendant in that case. He was a federal defendant. He's currently appealing his case, but it shows the back of a person looking at a house. Why is it an unwarranted invasion of privacy to disclose that picture? Why does it affect that person's, deprive that person of a fair trial to disclose that picture? Why does disclosing that picture interfere with the governmental proceedings or the law enforcement?
And that
proceedings?
was an admitted exhibit?
Yes, Your Honor.
Okay.
And the reason I just point to this, because I could point to any number of exhibits, is we aren't hearing the justification from the department as to why this particular exhibit should be. And that's really what.
Your argument's helpful. It distills it down. That's helpful.
And so when you can look at, some of the other cases that the federal cases that were incorporated by Evening News, for example, Ravish Turner, dealing with the Central Intelligence Agency and dealing with two affidavits, and specifically the supplemental affidavit that was provided by the affiant that goes through each picture and says, this is a picture that, that talks about a conversation from an overseas cable, so on and so forth. It gives some detail. The court in that case said, this in and of itself is insufficient because it lumps together the exemptions.
I had one of my Navy assignments was as the Department of the Navy's, in the office of the Department of the Navy, that was the appeal authority for FOIAs, and I was the commanding officer for a while. I'm familiar with a lot of those federal principles. It's been a long time since I was there though. So, but yeah, FOIA is the FOIA, the federal FOIA handbook, just a practitioner's guide. I don't know if either of you have it. It is literally this thick. It is so big. So anyway, but you're taking me down a memory lane on that one. So,
and again, of course, the department and the affidavit really, it's almost a more of a justification of the validity of the exemptions that are being claimed, as opposed to an application of those exemptions to the exhibits that are being requested by the requester in this case. And there's no doubting the validity of the exemptions. They're law. And
right.
Of course, we all care about the fair trial rights of defense. I practice mainly criminal defense. And so that's a huge factor. But again, how do each of the public records or the portions of the public records that are being withheld relate to those claims exemptions? And just, it defies factual and legal logic that all of the exhibits that were being requested are in their entirety withheld from disclosure because of all of the claimed exemptions. And so that's really the
okay.
The biggest premise I have.
Why is the Attorney General a defendant?
Because a suit against the state official in her official capacity is a suit not against that individual, but against her office.
What you're seeking a claim against an agent of the department, not the head of the department.
The claim is against the public body, not against the agent of the, it's not against the FOIA coordinator.
So why aren't you naming why didn't you just amend and name the department?
Because my understanding of the law is that the suit against the AG in her official capacity is a suit against her office, which is the Department of the Attorney General.
Okay, so you do not intend to amend?
If the court grants, I mean, if the court is inclined to grant the plaintiff's or the defendant's motion for summary disposition under C8 for that reason, then I would ask for leave to amend. But I simply don't believe that the law requires it, Your Honor.
Okay. Let me have a moment, please. Okay. Go ahead.
Does this court have specific questions you want me to just?
I'm looking at my notes. What do you hope to discover with the deposition of Attorney Hagman Clark?
Well, until today's date, I was unaware that the disclosure, the subsequent disclosure of the trial exhibits from Jackson County that happened on the same day that Ms. Hageman Clark invoked all of these exemptions for those, for some exhibits where there are obviously some cross pollination, some of them are the same public records, but that was being attributed to human error. You know, we have that in and of itself suggests, and that's why I wanted to brief the issue of Arabo, and I filed the motion for leave to supplement the briefing. But really the idea of if there's procedures and methodologies that are being employed by the FOIA coordinator, how do you have such a blatant discrepancy between the two? And really, I think the later redacted exhibits that are provided indicate that that's the more appropriate route. I can't tell Your Honor that is the more appropriate route in treatment of these requested records, because redactions could be made and portions of the exhibits, if not the entire exhibits, would be subject to public disclosure. So it's really to investigate further how these decisions were made, who is directing these decisions, what efforts were actually made to separate the exempt from non-exempt material in response to plaintiff's request. As I noted, and the court probably has seen, it was indicated that the request took minimal time to process.
That's what they said.
We have spent, I don't know how many hours in this litigation briefing these issues back and forth. These are complicated issues. So that it took minimal time to process is concerning, and indicates that really there's, whether it's a willful and intentional violation of the FOIA, whether it's an arbitrary and capricious treatment of the plaintiff's request, those are the things in addition to really the factual scenarios of how this response came about that we seek to discover. Additionally, in the request for admissions, the defendant denied that they hadn't provided a declaration or a description of the withheld records. They denied that they hadn't provided a bill of particulars. There is no bill of particulars. And so why are they denying it in the request for, in response to the request for admissions, if that's the case? I mean, there are factual issues here that have not been resolved yet by what we have.
Okay. Why do you think you're entitled to the writ?
The motion for the show cause as to why a writ of mandamus shouldn't issue, Your Honor, is because
Why is mandamus appropriate?
because it's an extraordinary remedy, and the way that the Attorney General in
Right,
this
but you
case
have to, it has to be for a ministerial task for which the executive agency has little or no discretion. The statute itself and a plethora of cases interpreting the statute talk, forests have been felled with the cases discussing the discretion of the agencies. How is that something that is ministerial in nature?
and I've thank you for bringing that up. I thought about that a lot. The thing that's not the portion of that section of subsection C of section 5 of the FOIA that is ministerial is the duty to provide a description. Now, whether the description is written in blue ink, red ink, or black ink, that may be some minute discretion that remains with the department, but they have to provide a description of the records that are being withheld. And that's what that is.
Right, but your client's FOIA request itself described I want the exhibits that were admitted in open court. I mean, he's And attached to his affidavit in your reply brief to this, or response brief to their motion for summary disposition, there's his affidavit, which is 25 plus pages long, very carefully prepared, has photographs of actual in-court images. And I do understand that the standard of whether a FOIA request is granted is not contingent upon the amount of knowledge that the requester has of the documents or other information maintained by the governmental agency. However, as far as the particularity of what is being sought, I think the court can look to the record as provided, and the record provided by you and your client shows he knows what he was asking for. It seems to me that this is, unless I'm misunderstanding it, the only thing that's been asked for is exhibits admitted in open court.
And their exhibit list related.
And the exhibit list, which I've already sort of telegraphed what I'm thinking on that. But okay, but those are the two things, right?
That's correct, Your Honor.
Okay.
And I guess I agree with the court that the identity of the requester and that analysis under FOIA is not necessarily exactly applicable to the writ for mandamus. And of course, there has to be, when you're talking about the clear legal duty, there has to be no other legal or equitable remedy available to the individual seeking the performance of the duty that would have that duty, but it pertains to the duty. And so the duty is to provide a description. It's a clear legal duty. He has a clear right to it under the FOIA. And providing the description in and of itself is a ministerial act. Now, we're not.
But listen to the words you just said. Providing the description itself is a clear ministerial act. We have you, opposing counsel, me, one of the law clerks from our court. We're all 4 lawyers. We've all been practicing somewhere from 5 to 40 years probably between the group of us. And I'll bet if we asked each of the 4 of us, okay, go write the 3 most important issues in this case, every one of us would write it differently. We would describe it differently. So the act of a public agent making a description of something, I guess to me, it's almost the opposite end of ministerial. Doing something, yes, but how it's done. Your reference was to blue or red ink or black ink, and I'm not sure that is directly analogous to the situation we've got before us. But I understand and appreciate your position.
And I understand the court's concerns with it. What the description has to contain, at least generally, is defined in the act. A description of a public record or information on a public record that is separated or deleted. So at a minimum,
okay,
identifying what's being withheld is required by the act, and that doesn't require discretion, Your Honor.
Okay.
Good. I want to touch base on something that came up in the argument, or in the defendant's argument, which is the case that was being debated with regard to the public domain, and it's Prison Legal News. And even in that case, and when you look at the privacy interest, there's an effort to define the privacy interest. There you're dealing with, depictions of a graphic corpse mutilation inside of a prison, right? And so the victim's family has a privacy interest in with regard to disclosure of some of that content, even though it was admitted at trial. But portions of the video and portions of the audio related to it were released. And so again, it's a nuanced approach. It's not saying, hey, this entire video contains graphic images. It's going through and saying, well, okay, what portions can we disseminate, and which portions are these valid interests? And again, when it comes to the interest, there was analysis of did the victim waive his interest in the depiction of his body after he was murdered and mutilated? No. Did the family of the victim waive their privacy interest in those pictures? No. However, in this case, with regards to many of the defendants, some of the items that are being withheld and are things that were shared on social media. are pictures that are taken of other people in public. And so how is it an unwarranted invasion of privacy if you're in public and someone takes a picture of you? It brings in a whole nother analysis. I don't necessarily have the answers for the court today. And I don't think that to survive summary disposition, we have to have those, but there's more inquiry with regard to not only the claimed exemption, but also with regard to the public domain doctrine and whether the claimed exemption can still be fulfilled now that these documents are out in whatever way that they're disseminated, some by the defendants prior to the proceedings, some by the government during the proceedings, some by the media during and after the proceedings. There's so much more that needs to be analyzed. And just touching base one more time, Your Honor, on the declaration, the revelation, the subsequent revelation of this exhibit list, again, discovery is not available to just have a hope for impugning the affidavit of the declarant. Hope for impugning the affidavit of the declarant. I'm sorry, I have a little bit of a speech impediment and I mumble.
No, you're doing just as your brother counsel did very well.
Why wasn't that raised in more detail in the affidavit? Why, if the exhibit list existed and now we actually have this information in far more specifics, why can't those specifics be applied to the claimed exemptions and we can find out what the justification actually is for each of these?
Okay. All right. Anything else?
No, thank you, Your Honor.
So if I'm
May I say one more thing, Your Honor?
You may.
With regard to the status conference and with regard to the
Right.
motions, the discovery in this case has really not been able to go forward. Mr. DeBear and I have been in communication about it from really the inception of the case. He indicated he would be objecting to discovery. He timely and promptly filed the motion for summary disposition.
Sure.
There was no ruling on it for quite a period of time. Eventually, the plaintiff and I decided, well, we need to at least try to notice one deposition so that we're not left sitting on our hands when the timeline or the expiration of the discovery period comes up. I guess depending on how the court rules, we do intend, and I'm sure that the defendant would object to attempt to depose not only the FOIA coordinator, Ms. Hageman Clark, but also because of the Attorney General's recent statements in the public about this case that are referenced in our response. And we certainly anticipate an objection to that and motions that would need to be hashed out before your court in that regard. So I would also be asking for leave to extend the discovery deadline.
right. And you raise a good point, counsel. It's clear from the record that you and your client have sought discovery. It's clear from the record that the people have sought to have a resolution for a summary disposition in lieu of, fully contested matters, which is certainly any litigant's right. And, whether it's under, Federal Rule of Civil Procedure 56 in lieu of an answer, or 12B6 in lieu of an answer, we provide for in our court rules. In the event that the case is not resolved by summary process, I fully understand you've sought discovery, and I'm not going to say, oh, nope, July 31st on discovery, you're done. That's not going to happen. We'll extend some times if we cross into that. So,
Thank you, Your Honor.
but
Thank
I
you for your time.
appreciate your pointing out. Thank you. You're welcome. Mr. DeBear, in response.
I'll do my best to be brief, but I'm not very good at that. So if Your Honor wants to or needs to cut me off, please go ahead and do so.
I have a question.
Yes.
How many pages of documents responsive to the FOIA request exist?
My understanding, hundreds, not thousands. But it's based off my understanding. It's not an exact number, obviously. But
Well,
by
okay,
way of comparison, the trial exhibits in Jackson County, I believe, were around 500 pages that were produced.
okay. So And how many, so about 500, somewhere in the ballpark of 500 pages. Were admitted in the Jackson case. What about in the Antrim case?
Yeah, off the top of my head, Your Honor, I'm not entirely sure if it's important to the court's analysis. I'm happy to go back to my office, pull up the records and email the clerk's office with the number of pages. Of course, with copy to plaintiff's counsel
That's
as well.
Go ahead.
So briefly, with respect to the discussion of the bill of particulars, it's the department's submission that Hagem and Clark's affidavit is the bill of particulars and that it did describe the category of records that were exempted from disclosure. There is no requirement, contrary to what plaintiff's counsel was representing, that
Have you ever filed a bill? Have you ever seen a bill of particulars?
So in the,
That's just a simple yes or no question.
I mean, a federal bond index bill of particulars.
Have you
I think-
filed a bill of particulars or lawyers in your office?
So I filed what I call exemption logs and supporting affidavits to address those exemption logs. In my mind, that's what a bill of particulars is. But in this particular case, generally speaking, under evening news, you don't need to have a Vaughn index, which is the federal FOIA terminology, as Your Honor seems to be aware, that identifies every particular record and how every particular record would do one of the following. You can, in lieu of the Vaughn index, and it's in the plain language of evening news, submit a description based off of a category of records. And that's what's done here. There's nothing in the plain language of the FOIA or in evening news that says a Vaughn index for each particular record is required. You can provide a description of a category of records.
Right, but evening news also says the following quote at page 503 of volume 417 of the Michigan Supreme Court Reporters. The burden of proof is on the party claiming exemption from disclosure. 2, exemptions must be interpreted narrowly. 3, the public body shall separate the exempt and non-exempt material and make the non-exempt material available for exception and copying. 4, detailed affidavits describing the matters withheld must be supplied by the agency. 5, justification of exemption must be more than a quote conclusory, close quote, simple repetition of statutory languages, period. A bill of particulars is in order. Justification must indicate factually how a particular document or category of documents interferes with law enforcement proceedings, period. 6, the mere showing of a direct relationship between record sought and an investigation is inadequate, period, close quote.
And it's the department's position that those 6 rules Your Honor just read from evening news we complied with and have made that showing. If the court disagrees and thinks that a more detailed bill of particulars that goes through the Vaughn index route that I just described, the department can certainly submit that if the court thinks it would be valuable. Relatedly, Your Honor, the court and plaintiff's counsel had a discussion about the identity of the FOIA requester or the knowledge of the FOIA requester being irrelevant or not part of the analysis. True, but what is part of the analysis is the particular records at issue in the FOIA request. And I will submit that those rules in evening news are designed because of that informational disadvantage and imbalance. And it is not irrelevant the fact that these exhibits have been presented to the public, are detailed in transcripts, and have been photographed by Mr. VanDussen. In fact, plaintiff's counsel showed you exhibits that were admitted. They already have some of them. There is not the same level of need to provide the court with a detailed bill of particulars as if it were the case, say, for example.
So do you think if the court does not agree with your position that 2.116 I2 relief should be given to the plaintiff?
I will submit that it's a legal question, Your Honor, and if it's the department's position that no further discovery is required because the matter is straightforward, it's a legal issue, and again, all the parties in the court have honed in on the fact that these records have been introduced to the quote unquote public domain. But there's no additional discovery that needs to be had because of that. And if the court, and again, the department is not asking the court to rule in plaintiff's favor, but the court is,
Well, it's
has
you're
everything
saying,
at its.
what you are saying is there's no discovery. It sounds an awful lot like your position is it's an either either or. It's either yes, we meritoriously and appropriately asserted and correctly withheld this information under the 1 through 3 exemptions, or we did not.
I would agree with Your Honor that it is an either or case. We win or we lose. If the court disagrees and the court thinks that it could be better benefited from a Vaughn index or an exemption log in detail, the department can submit one of those and will submit one of those if the court requires, because in FOIA actions, the trial court is unfortunately often the final FOIA coordinator, right?
That's what a wonderful description.
Well, they are right, because
I'm a final FOIA coordinator.
well, you're making the ultimate decision on what gets
Well,
released.
Nothing a trial judge is ultimate, so it's always reviewed by some very scholarly intermediate Court of Appeals judges, and then the very capable Supreme Court of our state that we have the benefit of.
You're certainly a ultimate FOIA, because you're doing the same ultimate thing.
Okay.
So
No,
if Your
that's
Honor does think that that would be necessary or helpful and instructs the department to do so, we will. As far as discovery goes, the need to depose Danielle Hageman Clark, for example, who is the division chief for the department's criminal trials and appeals division, who supervises these prosecutions, would be, the department submits, entirely inappropriate, given that she is the supervising person directing these prosecutions, and that the matter related to these FOIA requests is so inherently related to those ongoing prosecutions. It would put her under a position where, can I answer this? Can I not answer this? Is this about the case? Isn't about the case? And it would also create the need for the trial court, particularly, to be incredibly involved in the deposition process, because there would be so many instances where I would probably say, Ms. Hageman Clark, don't answer the question. And it's just unworkable. With respect to the FOIA coordinator, Ms. Wendling Richards, as Your Honor is probably aware from having served in the executive branch, the FOIA coordinator doesn't, I mean, I suppose my analogy about the final FOIA coordinator is a bit off now, but the FOIA coordinator, they coordinate the FOIA process.
Right.
They're not the ones that are saying exempt for non-exempt. They make sure the deadlines are calendared, they get the responses out, they process the request. But Ms. Wendling Richards, the department's FOIA coordinator, is not an attorney. She's not a prosecuting attorney. These particular decisions on the ultimate, is it exempt or not exempt from disclosure, are not within her, regular job duties. It's not something that she is asked to do. That is made by, those decisions are made by the prosecutors. If there is a point in time where the trial, where this court says, okay, well, this case is final now because there's a verdict. I see that there's a claim of appeal pending, but we have finality because there's a verdict. It can make that ruling, but the department's position, and it will be if there's any discovery, is objecting to the depositions of Hageman Clark or any of the prosecuting attorneys for those reasons, the ongoing prosecutions.
Be surprised if it weren't the position of the department.
Correct. And I believe that is, those are all the rebuttal points that I had, unless Your Honor has any.
I don't have any
questions.
more. I'm very grateful for both of your oral summations. We're going to take a 10-minute recess. We'll reconvene at 20 minutes before the hour. It's now, gosh, I don't know whether my watch is right, the clock is right. Okay, we're going to use the magic iPhone clock. So we'll reconvene at 10:40 That's about a 13-minute recess. In that time, I'm going to have some discussions with one of our law clerks who's been here with us, and then I'll come out. I'm not going to rule when we reconvene, but what I am going to do is give you a sort of a roadmap of the immediate future, if not the entire future. So anything further before we recess from either council or anything from? Okay, all right. Well, thank you. You're very kind. All right, court's in recess. Thank you very much. Very helpful. Hey, Ms. Fox, thank you so much for taking care of us today. It's great to have a court reporter back in the courtroom. So thank you so much. I'm very appreciative, and I know the lawyers, and I'm sure the plaintiff is grateful for your assistance, as is the department. So what's going to happen is the matters that are before the court are submitted and will be taken under consideration. Within the next day or two, hopefully yet today, I'm going to draft a very short order that just says, had the benefit of oral argument. The court is considering the three motions before it, and between now and when the court issues its opinion and order on each of the motions before it, discovery is going to be held in abeyance. Okay, and other matters in the case will be held in abeyance, with the understanding that if counsel want to work together and talk about stuff, work together to discuss, is there a middle ground that could be reached where, okay, we think we took the meritorious position, but we understand your positions. Now we're, let's talk about resolving this. I'm not telling you to do that. Don't miss, and I know I'm the finder of fact, so I'm not trying to get out of my lane, but while a case is pending, nothing prohibits capable counsel from having a meaningful discussion with each other. And maybe there is a middle ground. Maybe there is a middle ground that would work for everybody. I have no idea. Maybe there isn't. And I'm not going to withhold my opinion in order that is ultimately addressing the questions that are before the court in hopes that, oh, the lawyers are going to work this out. That's not what I'm saying. But as I've said, Mr. Stiglitz, your brother counsel had the poor misfortune of being on 2 conference calls yesterday. So he's already heard me on 2 completely unrelated cases where all the parties were represented. But I had a mentor, a federal judge, who used to say a bad settlement is better than a good verdict. So, maybe that's what would happen in here. Maybe you can say, okay, we've reviewed this. We think that, in hindsight, we're not acknowledging it, that we made a mistake because we don't think we did, but here's the materials. Could do that, maybe. And I'm not, and again, for the Court of Appeals, when you are reviewing my comments today, that I'm saying right now, I am not encouraging, directing, asking, or anything of that nature of these very fine lawyers. I'm just saying things are out there. If they want to try to work on something while waiting my opinion, that's fine. I'm not directing it. And I don't know if either lawyer, do you have any objections on behalf of people from anything I've said so far since we've been back on the record?
No, Your Honor.
Okay, I don't get the visual impression that it is, but I want to make sure the record's clear. On behalf of the plaintiff, any objections to anything I've said so far? Okay, thank you. And it's just meant in the, I've had the privilege of being a lawyer since 1985. And as lawyers, we have the privilege of representing our clients, and I've always just found that when I talked with my opposing counsel, and a lot of times things seem to work out. Doesn't always, and I've tried a whole lot of cases to verdict. So, and both as a trial lawyer and as a judge. So that was all I was trying to say. But what's going to happen is that we'll issue a short order that just sort of puts things in a holding status. I know I have case call next week, so an opinion substantively is not going to be out by the end of next week. It's probably not going to be out by the end of the following week. I do hope it's out by the end of June. Okay, is what I would anticipate. I shouldn't say anticipate. It's what I hope for. If we're able to do that, so be it. If we're not, we'll work on it. I'm not going to send you emails giving you an update on my calendar, so you won't be receiving that. But that's sort of where I'm thinking we should be heading, sort of procedurally, and then substantively, the court will speak through its opinion and order. But that's all I've got. But before we recess, I want to ask Ms. Fox if I've missed anything. And just as importantly, I want to ask our law clerk if I've missed anything. So Ms. Fox, anything that I've missed that you know of? Okay, perfect. All right. Well, the two people who have a better idea of what's happening, the court reporter and the law clerk, are saying I think I'm okay to continue. Is there anything else on behalf of the people that you would like to put on the record, Mr. DeBear? Okay, thank you. And Mr. Singleton, and I asked Mr. DeBear because he was the moving party and had the burden of proof. So Mr. Stig Nelson, anything on behalf of Mr. VanDussen or anything else before we adjourn? Okay, I want to thank the council and I want to thank Mr. VanDussen for being here with us today. Thank the court staff for participating and helping, Greg for keeping everything moving in the right direction and timely. The matter will be submitted. I hope everyone has a pleasant rest of the day and enjoys this beautiful. Now we are in June, believe it or not, in the great and wonderful state of Michigan. So I hope everybody has a great June. Court is in recess. Thank you.